want to warmly welcome you to the second free annual IVF conference.
Behind every surrogacy journey is a woman who says, yes, I will carry this life for you.
The process of surrogacy is natural. The egg, the sperm is fused together to form an embryo. It is still the natural course of things, only that it is aided or assisted.
We have
Before we judge, let us listen. Before we generalize, let us understand. And before we speak of surrogacy as a business, let us see it for what it can be, a profound expression of humanity.
Now, surrogacy in Nigeria. That's the main debate. Surrogacy in Nigeria remains a gray area in our legal system. Yes, there's this argument that there's no legal framework for surrogacy. When we talk about legal framework, the makeup of a country's legal framework is a combination of its constitution, its statutes, and case law. By constitution, we're talking about the ground norm, the document that forms the foundation and sets ground for any law that either the state or the National Assembly can enact. And case law is law made, we also refer to as judge-made law, laws that come about by judicial interpretation of matters before them and laws that exist. Now, when we're talking about whether there's a legal framework and focusing on whether surrogacy is well regulated in Nigeria, we are focusing on statutes, whether the existing laws, either at the national level or at the state level, to regulate surrogacy. Unfortunately, there have also just been bold attempts. There is no law in Nigeria regulating surrogacy holistically, comprehensively, in all its ramifications. There has been bold attempts, actually. In 2016, there was a bold step through the Assisted Reproductive Technology Bill of 2016. Unfortunately, that bill remains in the wait. It has not come to fruition. There was a recent attempt in 2004, that's the surrogacy bill. Well, that one ended at the second reading in the House of Representatives. But it's still there. Hopefully, something will be done about it. There are key highlights of those proposed bills that we're still waiting on to be enacted. These are key provisions that, yes, can help regulate surrogacy properly within our country. There's a plan to establish a surrogacy commission to oversee surrogacy arrangements, and also the issue of eligibility, but it's actually conditional, whether it's open to anyone or only persons who have been medically certified to be unfit to either conceive of or carry pregnancy. Then obviously, or as the one, it has to be altruistic, not commercial in nature. Well, these are still expectations. These are still in the pipeline. It has not come to be. But yes, we need to clap for Lagos State. Lagos State is represented here. Lagos State always in the lead. The pioneers, the pace setters. I always tell people, if you cannot invent success, you copy success. Lagos State, knowing that this is a matter that is ripe, this is a matter that needs to be dealt with, needs to be focused on and regulated, have come up with guidelines for assisted reproductive technology, ART, which includes surrogacy and practices that border on that area. The guidelines were established in 2019, so as far back as 2019, Lagos State has been doing great in regulating surrogacy within Lagos State. These are key areas covered by the guidelines. Yes, the agreement with the recognition of agreements which are treated as contracts, which means that they are to be subject to the law of contract. Respite and clarity comes when parties agree to enter into this arrangement. And of course, contracts, definitely, you know the ingredients of a contract: offer, acceptance, intention to enter legal relations. It must not be repugnant to natural justice, equity, and good conscience. It must not be contrary to public policy. The parties have to have capacity, all that. So once all those ingredients are satisfied, yes, there's respite. Then the area of ethical and clinical issues, including clinical practices, they've not left that stone unturned. They've ensured that the practices of donating sex cells, transfer of embryos, cross-border treatment, preservation, posthumous use, all that are regulated. It's no longer business as usual in Lagos State. Then they need to register the players in that industry, the practitioners, the healthcare providers, the fertility industry players. They're expected to be registered. They're expected to ensure that they have no business with unprofessionalism, no room for quackery. So that takes us to violation. Before violation, there's need for public awareness, which Lagos State has continued to embark on. There have been campaigns. This is one of such campaigns because, yes, there's a support for this program of today. And it's for that campaign to enlighten the populace concerning the existence of surrogacy and the guidelines that operate with it. The penalties of what anybody who violates any of these guidelines will definitely face the penalty, which is the essence of this, is to deter unethical practices. Now the question, is surrogacy a crime? Yes, we have said that there's no specific law. There's no, by means of specific law, it's a law dedicated solely to the practice and arrangement, the arrangement and practice of surrogacy in Nigeria. Now, there's one thing for there to be no law specifically to regulate this practice. It's another thing for there to also be a law specifically pronouncing an act to be a crime and also provide punishment for it. What is a crime? A crime is an act or omission that constitutes an offense and is punishable by law. Up to date, I've not seen any law books anywhere that specifically pronounces surrogacy as a crime, let alone to provide any punishment for the act. Now, no one can be charged and prosecuted for an offense. That does not exist. Of course, there are counter views concerning it, and we're going to consider the basis of these counter views. It's an argument. And the contrary views are derived from the Child Rights Act. We are going to look at the specific provision of the Child Rights Act. We're looking at Section 30, subsection 1. Yes, the whole of Section 30. It provides that no person shall buy, sell, hire, let on hire, dispose of, or obtain possession of, or otherwise deal in a child. Section 30, subsection 2A to F, prohibits using a child for begging, slavery, hawking, and activities that deny the child their right to education, prostitution, and drug trafficking. And of course, Section 33, a person who contravenes the provision of subsection 1 commits an offense and is liable upon conviction for a term of 10 years. Now, looking at this act, looking at it as a whole, reading it as a whole, it is obvious that this is meant to protect children who have been born. You know, a law, an act is not read in isolation. You look at it from the preamble, the intent of the framers of that law book. And a collective reading, particularly this section that is held strongly to advocate or argue whether it's a crime or not, reading it collectively shows that what this law guides against is exploitation of a child. Section 277 of the same act defines a child as any person under the age of 18 years. And that definition does not include embryos. That definition does not talk about the early stage of surrogacy plan, when nothing has happened, when it's just an intendment, a desire to help, to facilitate, to save a situation. That is not envisaged. The framers of this law obviously didn't have the mind on their minds, sperm, eggs, zygotes, embryos. You know, if crime is specific, if something would be declared a wrong and punishable, it should be stated, it should be mentioned. There's no room for conjecture. There's no room for assumption. It will be clearly stated and the punishment spelled out. Another act, another provision that has led to the consideration whether or not it's wrongful or a crime is picked from the National Health Act, Section 50, subsection 1. It provides that a person shall not manipulate any genetic, emphasis on mine. It provides that a person shall not manipulate any genetic material, including material of human gametes, zygotes, or embryos, or engage in any activity, including nuclear transfer or embryo splitting, for the purpose of cloning of human being. Then import or export human zygotes and embryos. Now let's understand what cloning is. Cloning is the process of creating an exact genetic replica of an organism, either by natural or artificial means. With all due respect, surrogacy and the process leading to the birth of a baby is not cloning. It's not cloning in any way. The eventual baby that will be birthed does not have the exact genetic replica. And as expected by every law, it provides a punishment for anyone who contravenes Section 50. If you look at this provision, you understand that this provision is just trying to find out, or not trying, actually frowning at genetic engineering, unethical manipulation for unethical purpose. The process of surrogacy is natural. The egg, the sperm, is fused together to form an embryo. It is still the natural course of things, only that it is aided or assisted. But when we are talking about genetic engineering and the likes that this law deters, we're talking of trying to create something else, trying to manipulate the order of nature, trying to formulate what is not. Scientists do that. That is what is being frowned at by that provision. So the underlying purpose of the enactment of the National Health Act is to just provide proper healthcare guidance and clarity as regards the things mentioned and discussed in that law. So, in this circumstance, in order to avert the confusion, the uncertainties, the exploitation that is inherent in surrogacy practice, it is advised that there needs to be a comprehensive law at the national level. Yes, Lagos State has done well. We give them kudos. They have guidelines to regulate it, but in Lagos State, that is why the issue or the surrogacy baby factory incidents, it has become old news, because there's a process for detecting and regulating the players in that other industry, unlike other states. So it's really worthy of emulation. This is a brief presentation of what obtains in the United States. We also have what obtains in the United Kingdom. Yes, they accept and they recognize surrogacy. But there's processes of which they regulate theirs in their countries. We have the Surrogacy Arrangement Act of 1985. We also have the Human Fertilization and Biological Act of 2008. In their system, they've been able to define and properly regulate surrogacy and how it should work. They've also gone further to provide steps for legal parenthood, so that once the child is born, there won't be confusion as who becomes the legal parent of the child. There are strengths and criticism in every situation, however, as much as their system, which promotes altruistic surrogacy, which helps to prevent commercial surrogacy, the process of getting parental orders takes some time. And also, before then, the right of the parenthood remains with the surrogate. Unlike the US, there are pre-birth orders. From the onset, you enter into your contract, you have clear terms. Before the baby is born, you can go to court and obtain orders, which already states that you are the parent of this child before the child is born. And that, with the contract involved, it clears any form of uncertainty. And of course, you know, the United States being a true federalism, the laws that operate in these respective states, they differ. It also has its own strengths and criticisms. There are clear pathways for intended parents, protections for surrogates, but one of the challenges is the expense, the cost of it. And like they say, any remedy that is not affordable is not really a remedy. So there's need for clarity. That is the solution to the debates and arguments surrounding surrogacy practice in Nigeria. There needs to be a comprehensive legislation. A surrogacy law should be enacted to regulate all aspects of the practice, all aspects of the arrangement. And also, the same law, or if need be another law, to regulate how parents, how their rights as the parents of the child is defined. And obviously, there has to be continuous enlightenment. In conclusion, proper regulation protects surrogates, intending parents and children born through arrangements of this, and it dismantles baby factories. Surrogacy and baby factories are worlds apart. While one of it is a regulated reproductive choice, the other is a human rights violation. So Nigeria must adopt legal safeguards to prevent exploitation while enabling ethical surrogacy. Thank you very much.